I'm here, my lord.
Yes, Mr. Sir.
My lord, I had made a submission last time about the speaker's conduct when he's faced with emotion. And my lord, one of the things your lordships have been considering is the problem about whether those observations of the earlier judgment of Nabam Rabia, whether they are to be read as a speaker being denuded of power to act, or whether he is being subject to a code of conduct. My lord, one can perhaps put it more on the manner of exercise of power, as I submitted last time,
Yes.
rather than absence of power, because there are 50 other functions which a speaker has to do. A speaker has administrative jobs. He has to run the assembly. There may be other things going on. Surely, my lord, one cannot suggest that the speaker must sit at home and sit it out till his motion is heard. There is some check and balance within the system, and your lordships have in the statute compilation the Maharashtra Assembly rules, and I believe there are similar rules in other assemblies too. Your lordships have Rule 11, which gives the time limit of 15 days. And my lord, my respectful submission is it may not be really feasible to say in black and white in what circumstances the speaker should or should not act. Normally, a person who's under a significant challenge should not act. If, my lord, a speaker, look at it's now academic, but the reason why we went to court is the speaker did not even give the period which you have to give for a reply under the rules. And it could be that the numbers were such that the speaker may have most probably lost his position. Because, my lord, one thing I do want to restate, I said this the other day, we know paragraph 3 about split has been deleted. One of the things which did prevail when your lordships upheld this law in Quixote as not being an anti-dissent but anti-defection law is that if there is a sizable number of breakaways, then it is not a defection. Then it is excess, because one has to balance the right to dissent with.
But Mr. Salve, then what is a sizable number of?
That's not for your lordships.
The then law will be bringing in split by the back door.
No, I'm sorry. I'm not inviting the court to do that. I'm saying something very different, my lord. In fact, my respectful submission is your lordship has to take it as you find it. There was a provision for a split which has now been deleted.
So therefore, the plain consequences that a split goes away.
No, I'm sorry, my lord. I'm not saying to the contrary. Till
so
that
whether
law,
it's a 1/3 or a 2/3 or
is this to be ignored today? That's irrelevant. If you are found to have crossed the line, it doesn't help you to say that the number of people who crossed the line was more than 1/3. But whether that law, whether Quixote, because Mr. Sibal also said maybe someday Quixote will have to be relooked, maybe even on this Quixote will have to be relooked, because has this law crossed the line and become an anti-dissent law is something your lordship will consider if the law is challenged. Because one thing, my lord, which your lordships would consider, yes, we know there is a problem about political morality, but that problem is on both sides of the fence. It cannot be once you're in, you lock the barn doors. To say that a person becomes chief minister if his entire legislative party is rebelling against him, you must wait till he goes to the election commission, then they get the party split at the election commission level. And then what happens? I go to the election commission and say, we are the real party. You come and have all your legislative members disqualified because no split now. So you come to the speaker and say, my entire party has rebelled, throw everybody out. I am the sole person, you can't remove me from chief ministership. But this is surely not what the law was meant to be. So all I am saying is, yes, we know there is a problem. And the legislature has tried to address it by bringing in the 10th schedule to the extent it has. But this overstatement saying because this is so, you must unscramble everything, you must transfer everything to Supreme Court, a resigned chief minister must be asked by a mandamus to come back and take office, or his accept of his resignation must be set aside. God knows what sort of reliefs have been asked for. So, my lord, my respectful submission is, and even as far as the governor is concerned, the solicitor is addressing your lordships. But since one of the issues does arise, is challenge to the governor's order. My lord, one thing which Bomai has laid down and laid down very clearly is that floor tests are not to be in Rajbhawan, floor tests are to be in the assembly. Head counting is not to be done in Rajbhavans because that is the root of a major evil. Whenever there is a question mark on the ability of the chief minister to command confidence of the house, the governor must call for a vote of confidence. The governor must not entertain people in Rajbhavan and do head counting. Now that's the law your lordships have laid down to prevent politics from entering Rajbhavan, if at all that is possible. So, my lord, when the governor calls for a vote of confidence, why should a chief minister continue in office even one day if he doesn't command the numbers? So yes, there is a problem of horse trading, but you are also leading a party. If there is a problem within your party, the problem is not only to be resolved in courts. So, my lord, my respectful submission is getting into this thicket, is inviting your lordships to depart from established constitutional principles which are judicially manageable. We have judicially manageable standards. Your lordships have said floor tests are the test. Let democracy play out in the floor of the house. That's a lodestar of this law. The governor did nothing wrong in calling for a floor test.
Yes, Council.
Yes, ma'am. So, my lord,
Yes, Council.
Yes.
yes. So, my lord, my respectful submission is on the 3 steps. As far as the Navam Rabia judgment is concerned, first of all, that question doesn't arise, and it's not a matter which is free from difficulties. But if your lordships are persuaded to get into, my lord, relooking that judgment, then there has to be some discipline. And that discipline can be brought in by a doctrine which we understand, and that's abuse of power. So, my lord, it's not absence of power, it's the manner of its exercise. And if in the facts of a case you find that there is abuse of power, a speaker has jumped the gun and done something which he shouldn't have, the courts are there to remedy it. So, my lord, that is the submission as far as Navam Rabia is concerned. Now, my lord, one other question which had come up, which I mentioned and your lordships are also seeing, can a mandamus issue to the governor to decide? My lord, that actually stands answered, because although it had been referred to 5 judges, a later judgment answers it, my lord, based on the observations in Rana. But on first principles also, my lord, there should be no difficulty. If your lordship sees the Quixote judgment on this, the problem which is sort of the genesis of this submission is paragraph 54 of Quixote. My lord, it's in the compilation, PDF page 111, the judgment's compilation. And the limitation on judicial review comes out of paragraph 7. And the question really is, my lord, in one sense, a mundane question. What is the meaning of the phrase quia timet action or an interlocutory intervention, which your lordships have said is not permissible?
54.
Para 54, my lord. In fact, the well-known rule in Maskin Company that this has to be strictly construed. And once your lordship has held that the speaker is a quasi-judicial tribunal, then, my lord, this has to apply in that sense. If your lordship sees para 62, in the present case, though the amendment does not bring directly any change in the language of 136, 226 and 227, however, in effect, para 7 curtails the operation of the articles and matters falling in 10 schedule. There is a change in so and so within the meaning of clause B of 368.2. Para 7 therefore attracts the passage having regard to the introduction of so and so, the 10 schedule, in effect bring about a change in 136. So, my lord, it is in this context that your lordship said you cannot have a quia timet injunction in para 54. Now today, my lord, law has moved far ahead, including, my lord, the proposition that even by constitutional amendment you cannot water down 226. We have had the later cases. But, my lord, I don't see this as a problem on the issue which your lordship is considering. the later judgment where Justice Nariman has gone into the definitions, a 3-judge bench, my lord, 2020 SCC online, SC page 55. In this very bundle, your lordship will find it at page 1324.
It's 3024.
What's the cause title, Mr. Salve?
It is Kesham Meghchandra Singh and Speaker of Manipur.
Bookmark 32.
Ilsham.
There are two, 31 and 32 both.
I think this is 32. 31 was the first one.
Right.
31.
Yes.
It's a bench of 3 learned judges. What your lordships did in this case, because here this question came up, your lordship said we have referred it, but without noticing that the matter already stands answered by Rana. And the relevant passage straight away, if I may cut to the chase, my lord, if your lordships come straight to page 1332 PDF, para 20, citing from Rana. In fact, my lord, if your lordship turns to page 1331, from para 15, your lordship starts citing Rana's judgment. And at the extract, my lord, in para 17 of this judgment, which says, after referring to the court's decision in Kyoto and Ravi Nayak, in para 22, the court held, then in para, your lordship's extract para 22, suffice it to say, decision of the speaker on 6 September was not immune from challenge before the High Court in 226, 227. The court then went on to hold, then para 25, on the scheme of 102 and 191 of the 10th schedule, the determination of the question of split or merger cannot be divorced from the motion before the speaker seeking the disqualification of members, therefore not possible to accede that under 10th schedule, speaker as an independent power to decide that there has been a split or merger as contemplated by para 3 and 4. The power to recognize a separate group in parliament may rest with the speaker on the basis of rules of business, but that is different from saying that the power is available under the 10th schedule to the constitution independent of a claim being determined.